of removal if the victim is in removal proceedings. And there's also battered spouse waivers. So if the victim has already obtained permanent residence but has conditional permanent residence, there's a waiver option for filing the joint petition to remove those conditions under VAWA. There's also gender-based asylum and special immigrant juvenile status, which both, of course, also deal with immigrant victims of trauma. However, because this is a short session, we'll only be covering the top 3 forms of relief today. What I did include, and I think you guys have received, is a couple of handouts, and one of the handouts does go into like all the basics of all these forms of relief. So just to give you kind of the initial details that you need in order to screen someone for any one of these. So today we'll start with VAWA self-petitions. So the benefit of VAWA self-petitions is that it gives victims of domestic violence the ability to still obtain lawful permanent residence without the abuser's need to cooperate. And then in addition, it protects any of the information that the victim of domestic violence provides. And I just want to correct myself. I mentioned she, but it's actually, it could be male or female, obviously, child or others. So essentially, the VAWA self-petition puts the victim back in the same situation that the victim would be in had there been no abuse by their spouse or by their qualifying relative. So let's go into some of the details about that. Okay, so the general requirements. The abuser must be a U.S. citizen or lawful permanent resident spouse, U.S. citizen or lawful permanent resident parent, U.S. citizen son or daughter, which for immigration law purposes means a child over 21 years old. So those are who the abuser is, right? If the abuser is not a U.S. citizen or permanent resident, unfortunately, VAWA is not the option, and perhaps one of the other legal remedies is available to them. Okay, so that's a good starting point, is checking the status of the abuser. Another point I'll make about that is if the abuser starts out as perhaps some non-immigrant status and later obtains lawful permanent resident status, then the VAWA self-petition may then apply at that point. Okay, so abuser is a lawful permanent resident or a U.S. citizen in one of these qualifying relationships. So the victim suffered battery or extreme cruelty. So we don't refer to it, the statute doesn't refer to it as domestic violence generally. It specifically refers to battery or extreme cruelty. And that, you know, can include obviously more than just physical assault. And I think is the reason why, you know, later on when Karen presents on victims of trauma and how to work with them, because so many suffer either both battery and extreme cruelty or just extreme cruelty, it's really important to be able to get from the victim exactly what all the things that she or he suffered in the relationship. They must have resided with the abuser. They must be a person of good moral character. And if the abuser is the spouse, then they also have to show that the marriage that they were in was a good faith marriage. This is because, as I said, you're putting the victim back in the place where they would be had there been no abuse in the relationship. Good faith marriage is a requirement to be shown in a family-based petition generally, right? If the abuser wasn't an abuser and filed an I-130 petition for his or her spouse, they would have to show good faith marriage. So the requirement is the same for victims of abuse. Okay, So what's the evidence? That's where the standard is a bit different. And under the Violence Against Women Act, the standard of proof is any credible evidence. The burden of proof is preponderance of the evidence. So preponderance of the evidence really means more than 50% likelihood. Okay, so 51% likelihood that they have proven the requirement, right? And standard of proof, any credible evidence, means that the adjudicator can take into account other evidence that may not be the best evidence in the case, right? But can include secondary evidence or what is considered credible evidence that will still be able to meet that burden of preponderance of the evidence, right? So what are some examples of credible evidence? Probably the most important one, if it's available, is systems evidence. And what we mean by systems is like official government agencies or official local agencies. For example, if you are trying to establish that the victim was physically assaulted and as a result of that physical assault was hospitalized, then the systems evidence that you would show is some record from that hospital, right? If you don't have that available, then you want to include the applicant's detailed declaration about each of the factors that you're trying to prove. Going down the list, obviously corroborating evidence from counselors or others who were aware of the harm or aware of the relationship or aware of one of the factors that the person is trying to prove. Be creative with your documentation and collection. One example I'll just give you quickly is if a counselor, for example, is trying to show the person's good moral character, well, it's one thing for her to just say, she's a good person. Something that would be helpful is if the counselor has direct knowledge of steps that your client has taken. For example, I have witnessed the client attending the children's after-school activities, and in addition, she is a volunteer at the school in order to both be close to the children, but also to give back to the community. Okay, so that's a little bit more information than probably a counselor would normally give. They would probably usually focus more on the domestic violence, but that just is an example of if you don't have the exact evidence that you're looking for, it's an example of how you might use one piece of evidence in two different ways. Okay. Spousal relationship with the abuser. So first and foremost, of course, we need to show that the abuser is a U.S. citizen or permanent resident. Documentation is not always available, so as much information as the victim has will be helpful. So if they have a Social Security number, even though they don't have the Social Security card, obviously all the biographic details of the abuser, so date of birth, place of birth, and any other details that they may have if they don't have an actual copy of the birth certificate or immigration documentation. If it's a spousal relationship and the state in which they were married or the country in which they were married has common law marriage, then immigration will accept that as a legally valid marriage for immigration purposes as well. So take a look at where the marriage took place in order to determine whether they meet the qualifications of common law marriage if they don't have an actual civil marriage certificate. If the couple is divorced, if the divorce is still within 2 years, if the petition is filed within 2 years of the divorce, then the self-petitioner is still eligible for relief. So the whole case doesn't have to be adjudicated and complete within those 2 years. It just needs to, the self-petition just needs to be filed within those 2 years. If there is bigamy by the abuser, the self-petitioner can still file. And so what does that mean? How could it be in good faith, right? How could it be a legally valid marriage? Well, there's an exception that was made for victims of abuse, because sometimes that is part of the abuse on the victim, right? So the most important thing is that the victim entered into the marriage in good faith and believed that their marriage was legally binding. So in other words, the bigamy is only by the abuser and not by the survivor. And then in terms of good faith marriage, the standard there is, was the marriage entered into for any reason other than solely to get immigration status? Usually the answer is yes. It doesn't have to be love. There's nothing in the immigration law that says the husband and wife had to be in love. There are many other reasons why couples get married, but it'll be important to explain that, to explain the nature of the relationship, and support that with any credible evidence. So what are the benefits under VAWA? Well, if the VAWA self-petition is, on this slide we're talking about benefits. Okay, so there is a special unit in USCIS that will adjudicate VAWA U and T applications. The officers are trained on how to work with victims of domestic violence, serious crimes, and trafficking. And so that's important to know, because for VAWA in particular, the first step is the self-petition. The second step is the actual application for permanent residence. And at that point, the local district office of USCIS will conduct an interview in order to determine whether the person is admissible as a permanent resident. So even though the local office is involved in that second part of it, only the Vermont Service Center or the Nebraska Service Center in case of the U visa, but only these trained officers who have this additional training can adjudicate or can revoke a self-petition. If a couple of other benefits that are important to point out, just because it's different from other family-based or other immigrant petitions, if the victim or survivor receives public benefits, if they are legally available to them and they legally qualify for public benefits, the survivor can obtain those public benefits, and it's not going to affect her lawful status. In order to access the public benefits, usually the first, for VAWA self-petitioners, usually the survivor will need at least a prima facie determination made on the self-petition. So it may not be final adjudication of the self-petition, but they'll need at least the prima facie determination. Once they have that, in some states, and unfortunately it's limited number of states, there are some access to public benefits, and that will not later affect their immigration status. If the self-petition is approved, the self-petitioner will have two things. They will have ability to get work authorization, and they'll have deferred action. And what deferred action is just immigration saying that it will not take steps towards removing the individual. So during that period of deferred action, then the self-petitioner can then take the steps necessary to file for permanent residence. They may work lawfully and kind of stabilize their situation. Another additional benefit is that derivatives, minor children of the survivor, can be included as part of the self-petition. So the survivor does not need to file a separate petition for her minor children. And so in this case, it's children under the age of 21 who are single. That's what a child would be for immigration purposes under the VAWA self-petition. Even if the children are abroad, they can still be included, but their process for coming into the U.S. will just be slightly different, as they'll have to go through the U.S. consulate in the country where they're living, rather than adjusting their status while in the United States. Okay, so let's talk about the process. So when a victim files a self-petition, and if the victim is able to demonstrate that she or he meets all the requirements, then the second step is applying for permanent residence. So there must be a approved petition in order to then file for permanent residence. But because we're putting the victim in the same place that they would have been had there been no abuse in the relationship, then the visa availability, in other words, the availability of permanent resident status, will be dependent on whether the abuser is a U.S. citizen or lawful permanent resident, which is the same as if the case were under family-based immigration requirements. So for a spouse of a U.S. citizen, she'll be considered an immediate relative under immigration law. And what that means is, for practical purposes, is that immigrant visas, lawful permanent resident status / green card, it's referred to as any one of those. So immigrant visa is immediately available for the abused spouse of a U.S. citizen. And what that entails is that because there's an immigrant visa immediately available, then the victim is able to submit her petition together with the application for permanent residence. There's no need to wait to file that. Unfortunately, for a victim of a LPR abuser, they do have to wait for their priority date to become current. And because there are not immigrant visas immediately available to spouses of U.S. citizens, so there's a set number each year, and when that number of immigrant visas runs out, then they have to wait for the next year for additional visas to be available. So the date of their filing is how it's determined when they will receive when a visa will become available. Okay, if the victim already has permanent residence and there's abuse and she must leave the abusive relationship, for those who have been married to the abuser for less than 2 years, they will receive conditional permanent residence. So it's all the rights and responsibilities of permanent residence, but it's conditioned on the marriage continuing. And so the condition is, we'll give you the permanent resident card, but you'll get 2-year expiration. And when those 2 years are up, you jointly file with your spouse to remove that condition and you continue on. So if there's abuse, obviously you can't file with the spouse. There's a waiver available under the Violence Against Women Act. And so there's other waivers available as well: divorce, death of the spouse, domestic violence, which is the one under VAWA, and extreme hardship. Again, it's when you're asking for the waiver, you're asking them to waive the joint filing requirement. You're not asking for any other waiver of admissibility or anything else at this point. So it's just waiving the need to have the abuser as part of the process. I'm now going to just switch quickly and go through U visas and T visas. I'm just going to go over the general requirements since this is kind of a basics webinar so that you can be able to issue spot. But if you need additional information, at the end of this PowerPoint, my contact information is on there. And in addition, our organization's website is on there, which has a clearinghouse with a lot of documentation, a lot of other training material that you might find useful. But I let you know that caveat that I'm going to go through the rest of it a little bit quickly. So the U visa is for crime victims, and The requirements are a bit more than what you saw with the vow of self-petition, but on the other hand, the outcome or the benefit is just as much protection as for a victim of domestic violence. So what they're showing is that they suffered substantial physical, emotional abuse as a result of being a victim of a qualifying crime. It's a qualifying crime if it is listed on in the statute. In addition, the survivor has to show that they had useful information about the crime and they gave that information or were helpful to law enforcement or are helpful right now to law enforcement or will be helpful in the future, right? So it is, was, or likely to be. So even if a person helped in the past and the case is completed, the criminal case is completed, they'll still be eligible to meet the requirements of a U visa. So the crime had to occur in the United States or otherwise violated U.S. law. And the person must be either admissible as a non-immigrant U visa holder or qualify for a waiver of any grounds of inadmissibility. So this is just what's in the statute in terms of types of crimes. You'll see domestic violence is included as one of these, and that's important to note because if, for example, the abuser or perpetrator of the domestic violence is not a United States citizen or lawful permanent resident, but the crime was reported to the police and the victim was helpful, then the victim may be eligible for a U visa instead of for relief under the Violence Against Women Act. But the statute itself at 101A, 101A15 little u, has the actual list of the crimes that are included. The benefits that they get. Okay, instead of being able to go directly to filing for permanent residence, the U petitioner gets valid non-immigrant visa status. So non-immigrant essentially means temporary period of stay and temporary reason, right? So, for that time period of U visa status, they're not a permanent resident, but they're in the United States lawfully. They are able to work in the United States lawfully. Employment authorization is incident to status, meaning they're immediately available as soon as the petition is approved. But unfortunately, the regulations do say that they have to have an actual work authorization document. So the approval notice of a U petition is not enough for them to be able to work. They actually have to have the EAD issued, but it is issued automatically when the petition is approved. They don't have to file an additional I-765 application for the work authorization. The U visa petitioner can include derivative family members. They can apply for lawful permanent resident status after having 3 years of continuous presence in U status. Most grounds of inadmissibility can be waived. That's super important. Because for normal non-immigrant and immigrant status, there are many grounds of inadmissibility that apply. They're all in INA section 212A if you want to take a look at them. But what the U visa statute says is that if they're applying for a U visa other than national security risk or terrorism or being a Nazi, pretty much everything else can be waived. And like the vow of self-petitioner, if the petition is approved, some states have public benefits available to U visa holders. So we talked about having one of the requirements being helpfulness to law enforcement. In order to show that helpfulness, they have to have the law enforcement agency that they helped sign a certification that says that what the crime was and that it's a qualifying crime under the U statute, that the applicant was the victim of that qualifying crime, that the applicant was, or will be helpful, and that crime violated U.S. law. This just goes into who can certify. Obviously, anyone you would consider who could investigate or prosecute crimes is on the list. But in addition, there are some local, state, and federal agencies that you don't necessarily always think about having the ability to investigate crimes. So as an example, State Department of Labor or Federal Department of Labor, CPS, if there's child abuse, EEOC, if it's an employment situation. And so I'm going to skip over some of the information on U-Visa, but I included it in your PowerPoint just so that you could refer back to it. I'm going to go ahead and go into, actually, I'm going to cover one more thing on U-Visas, talk about Ts, and then turn it over to Karen. Right now, there is a cap of U-Visas available. It's a statutory cap. There's only 10,000 available every year, more than 10, every year since about 2014, I believe. That cap has been reached. And so as a result, there's a wait list. But fortunately, there are benefits to being on that wait list. So I mention this only because I don't want to discourage, or you to discourage anyone from filing this type of petition. Take a look at derivative family members. The classification of family members is different for children. There are some instances where under 18 instead of the usual under 21 is going to be important. Okay. So T-visa eligibility. This is for victims of trafficking. They have to show that they have been a victim of trafficking. They have to be physically present in the United States because of the trafficking, and they have to be physically present when they apply. Unfortunately, they can't apply from abroad. They have complied with reasonable requests of assistance in investigating or prosecuting the trafficking. They would suffer extreme hardship involving severe and unusual harm if they were to be removed from the United States. And they are either admissible or eligible for a waiver. There are different types of trafficking, and so sex trafficking is specifically defined in this manner as either the use of force, fraud, or coercion, or if the victim's under 18, they don't even have to necessarily show that there was force, fraud, or coercion. Merely being under 18 is sufficient. There's also labor trafficking, even though we don't hear about it often, and so I've included that as well. Here's some red flags to look for, and as you develop your case as well, to go through these. Essentially, it's what kind of control did the person have over their life, over their well-being, or over their work conditions in the case of some labor trafficking. Benefits are similar to the U-Visa, 4 years of T-Visa, but the difference in applying for permanent residence is that they could either have the T-Visa for 3 years, or if DOJ certifies that the investigation or prosecution has been completed before those 3 years, they can apply as soon as the case is completed. Also can sponsor derivative family members, and that's true even if the family members are abroad. So the T principal has to be in the US, the derivatives do not. And finally, I'm just including here inadmissibility. Don't forget about inadmissibility. Even though it's for purposes of permanent residence, it's something that you think about in the second step after you've actually gotten a petition approved. Think about it at the beginning for every type of case, because it applies immediately for non-immigrant visas. But in addition, you want to know up front what the potential issues are going to be once they submit the application. This is particularly true because of the RFE and Notice of Intent to Deny memo, policy memo that was issued by USCIS, and the recent Notice to Appear memo, which is now being implemented for victims of applicants of humanitarian type of relief, like all the ones that we talked about today. So just know that that you have to go through all of the grounds of inadmissibility and then look to your forms of relief in order to determine what waivers might be available. Here's a little cheat sheet on everything I just went through, since I went through it quickly. And again, the materials that I provided also have some additional information. So I will turn it over to Karen, and then she'll get started. Hang on just one second.
All right, can you hear me okay?
Yeah, and now, Karen, you're Alan Mickey, right?
Nope, I'm Karen Crawford.
No, on the screen you're coming up as...
Hey, Laura, I'll change her to be presenter.
Okay, thank you.
All right, can you hear me okay?
Yeah.
Good. Excellent. All right, so I'm going to pick up here with handling trauma. And one note is that we're talking about immigrant victims of crime, but really you're going to come up with trauma in any sort of immigration practice, whether you're doing a waiver or asylum or anything like that. So it's helpful even if it's not specifically a VAWA case or a U case or a T visa. Before I go on to the screens about how to deal with this, remember, not everybody is traumatized and people have different levels of trauma. So you can have people expressing this very differently. Also, remember that sometimes people have prior traumas that make them re-traumatized later on. So if a person, for example, was a victim of a violent crime and had a history of child abuse, they're going to react a little bit differently to everything. At the very end of my slides, I have a couple of resources for you. One that has to do with trauma itself, and another that has to do with self-care, because part of my presentation is about that. So traumatic memory, when you have a trauma, your brain kind of breaks it all up into pieces so that it protects you from reliving consistent pain. So a lot of times people they don't remember trauma the same way they remember what they had for lunch today or their child's first day of school. So sometimes it's hard to work through trauma and work on an affidavit because the memory's all broken up into pieces. Sometimes it's broken up into their senses. So there may be a smell that makes them remember something, or a noise like a car backfire. A lot of times you hear people talk about that, or an image of the event, but not necessarily all of them at the same time. Parts of the memory is going to be vivid, and part of it will just be completely forgotten. And it's because of that, it's really difficult for your client to reconstruct it. You can't kind of force them through on a chronological basis sometimes. One really important note, because as lawyers and as advocates we think about credibility, is that sometimes the emotion gets displaced. So, for example, I had a client, an asylum client, who could tell you the most horrific details of her story with absolutely positively no emotion. It was like she was just telling me what she had for lunch. But then she talked about losing her purse and would break down in tears. So trauma will do that to you. It's not an issue of credibility as much as it is an issue of how your brain is, if I'll get these slides right in a second, how your brain is holding on to it. So as you're working with your client, you want to make sure you have resources available for them, especially people who are very traumatized. Know where they can go for some therapy. There are places that can provide free trauma therapy, group therapy, or individual therapists in your area. Some people cannot talk about the trauma at all before they've had therapy. Sometimes you don't have that option, but you just have to recognize that you need to stop your legal work, let them go and get treatment, and come back to it. Some will need trauma therapy after meeting with you. So I've had clients that have scheduled a meeting with me and then immediately went to their therapist afterward to deal with the repercussions of that. So you want to discuss the option of therapy with your client. Remember, some people, they've never thought about therapy. It's something that's never been part of their worldview. And so discussing therapy to them might be the first person that's ever mentioned it to them. One thing that I know clients have said to me is that they're worried about being considered crazy. And I always tell them that trauma and the emotional and psychological effects of trauma is a normal response to an abnormal event. So if they're having symptoms, it's because they are handling it the way they're supposed to be handling it. And getting that help will just pull it all together. And when in doubt, if you're not sure, have a therapist available to you. A couple things that I just wanted to throw in there too is that people are overcoming a lot of some people, for example, if it's an asylum case or if it's a case of some sort of severe domestic violence, they're breaking bounds of secrecy that they were supposed to hold for a long time. So it's hard to open up to you. They've also suffered a breach of trust in the past. Sometimes if they're talking about something that happened, for example, to a child or a spouse or somebody else, they can have feelings of guilt come up. So there's all sorts of emotions that are there. So the next slides, what I'm going to do is give you some structural ideas of how you can help work through this with your client. So the biggest part about this is that trauma is chaos, and you're trying to provide some order for your client. Trauma is danger, and you're trying to provide some safety for your client. You want to have be a place where they feel safe. And all of these ideas are ideal. Obviously, it's not going to work in every circumstance. But the biggest part about this is keeping your client informed from the very beginning about what's happening, touching base with them over and over again, helping them center themselves, and helping them feel grounded. Telling them what's going to happen next is very helpful. So first, you want to have a time limit. This is good for both of you, actually. You want to set a maximum time that you're going to be meeting with your client. You let the client know how much time that is, just like you would be in a therapist's office. Say, we have 10 minutes left, and you let them know as you go along. Walk them through what you're going to do. If you're going to take notes on a computer, they can't see the computer. They can't see what you're doing. Let them know what you're doing. If you're taking on a pad of paper in front of them, same thing. I find it helpful to let people know that I'm going to ask a lot of questions over and over again, and the reason is they may feel nervous thinking that somehow you don't believe them or start going back to trust issues that they had in this traumatic situation. And I just let them know the only reason I'm doing it is to make sure that I am telling their story correctly. And as you finish one part of your meeting, just tell them, all right, we're going to finish this part of the affidavit. Now we're going to do forms, or now we're going to do something else, and just kind of walk step by step through it with them. Let the client know that they can stop at any time. They have to have some control over the situation. They can pause, they can get up, they can walk around, go to the bathroom, get a drink of water, anything that they need to do to feel comfortable. Also, it's really important to let them know that they can skip over something and come back to it later. Sometimes it's the most important part of the case. You really want to get into it. They're having a hard time, but give them that power and control. Give them that ability to say, let's come back to this. I can't deal with it right now. Ask them. Some clients, they want to please you, or they're looking at you as an authority figure, and they don't want to say anything. So just stop at different points of time and say, hey, do you need a break? Do you need to go get some water? Do you need anything from me? And then when you finish that, once again, wrap it up again and tell them what's next. What are the next points? What are the next things that have to do? When is your next session? What's going to happen at that next session? A local therapist suggested also having something available like a stress ball or something that they can hold on to while they're talking to you is a good idea. So, tips for getting the story. So I had mentioned before that you want to have a time limit for your session. Don't go over 2 hours. It's just too exhausting for both of you. I usually try not to go over an hour, maybe an hour 15 minutes, maybe maximum an hour and a half, because it's really just too exhausting after that. So remember about centering your client. Remember about grounding your client. Just kind of keep those things in your mind as you're going through. Most people can get through this with no problem. These things that I'm bringing up here are really extreme cases of trauma. If you see a client that's just uncontrollably crying or is very upset or shaking or their eyes are going back and forth, there's something that makes it look like they're really, really upset, then you can use their five senses to bring them back. Say, hey, can you see something? Can you see that bird outside the window? Can you see that box of Kleenex? Could you pass it to me? Something that kind of brings them back. Oh, do you smell that coffee or that popcorn? Did you hear that car drive by? Something that helps them come back to reality at that moment. One thing that you can do as well, some of you may be familiar with this for people, if you know people who have panic disorder, is to have them name one thing for each of the sentence. Give me one thing you can hear, one thing you can see, one thing you can smell, and that's something that helps them bring them back out of that trauma response into current day reality. Now, one idea that a social worker gave me that works with victims of trauma, I loved it. I thought it was wonderful because I had a client was having just really heading into a panic discussing an incident of domestic violence. The problem with it is that when the person is entering into that emotional state, you can't really get their story. So you want to try and get away so that it's safe for them to talk and you're not talking for 2 hours and not really getting anywhere. So she suggested you say, if I were in the room with you, what would I see? And that does two things. One is it makes that person feel protected, that you're in the room with them while their abuser they're recounting this moment that they can remember with vivid detail, but you're standing right there with them in that moment. It also reminds them that they're not there, that they're just reporting an incident. It's not actually happening. A couple notes here. I want to skip some of these. You can read them, but it's best if you're speaking alone with the client. If there are children present, they don't want to talk about things that are difficult in front of children. If there's a person there that's a friend or a family member, sometimes they don't want to open up in front of that person. And of course, you have to deal with confidentiality. So there's some notes there about that, as well as about gender. Always make sure that, especially if it's the opposite gender, check in with them ahead of time and make sure they're okay with speaking with you about really difficult moments. So wrapping it up is the same idea that I talked about at the beginning, centering and grounding and giving people information, but also wrap it up for yourself. I've always found it helpful after I finish a session, not immediately after, but close enough that it's fresh in my mind, to write up all my notes into some sort of affidavit form. And that helps me realize where my gaps are and gives me questions for the next session. It also helps me download all of these thoughts that are going through my head as I'm hearing all these difficult stories. When you do get to your client and you have your affidavit, a draft of an affidavit ready, read it all back to them to make sure you've understood everything correctly, especially with traumatic memory. Sometimes what you hear from the person isn't exactly how it happened. So when you read it back, sometimes they can correct those little details. But also listening to it can trigger more memories for them, so it can give you a fuller affidavit. But be mindful that you're reading back the most difficult moments in their lives. It's going to be really hard for them. So watch their reactions, stop whenever you need to. And this sounds really daunting. If you've never done this before, this can sound like, I don't think I can do this. This is just too hard. It's actually some of my favorite work to do. When a person is recovering from trauma, going through this process of telling their story, you may be the first person they've ever talked to about it, so that there's somebody telling them that it's okay, that it wasn't their fault, that you're there for them. That's huge for them. But also, to recover from trauma, you have to integrate all those memories. You have to put it all back together. So preparing an affidavit is really helpful to your client's recovery, even if it's painful for them. So just remember that that's really helpful for them. Now, attorney self-care. This is kind of anybody who's practicing immigration law, you're going to know that this has been an incredibly difficult time for everybody who's practicing immigration law across the board. When you add in traumatized clients and their stories, it's even harder on the attorney. And this is a time now where our clients are not just suffering trauma and going through a difficult time, but they're also really anxious because of what's going on that they see in the news, just like you and I see in the news. So all of that energy is coming to you. You're really opening yourself up to your client as you're getting this story and being their advocate and their ally through it. So you really have to take steps to prepare to care for yourself. secondary traumatization is very real, and you don't realize it's happening right away. I'm sure many of you have had nightmares about what's happened to your clients or start feeling some of the emotions that they do. So you want to ground yourself as well. You want to ground yourself before and after the meeting. Have a picture on your desk of something that makes you happy. Have something planned ahead of time for after the meeting. Now, some of you won't be able to do this because you might work in a place where you have to do these meetings constantly, but try not to schedule really traumatic meetings back to back. If you're always going to be working with survivors, don't do 2 affidavit sessions back to back. Do an affidavit session, do a document gathering session afterwards, or forms or writing letters to your client. Do something right after the meeting, whether it's administrative research, anything you can do to walk away a little bit from that intense trauma. If you can, really trying to break this into yourself is take a break after the session, go for a walk, listen to music, go talk to a friend, do something to completely pull yourself out of that meeting. Breathe deeply helps with everything, and so always remember to be doing that during the session as well. Now, if you do have to do this regularly, or if you're doing something else that's pretty stressful, you want to make sure that you have some sort of regular activity in your life that pulls you out of the trauma and the anxiety of all of this. And there's a few activities there that are helpful. Maintain healthy boundaries. You create an incredible bond with your client as you go through this. You may be the first person they've opened up to. You're feeling so much, everything they've gone to, you admire them for their strength. And so there's a closeness that occurs in that moment. Remember that it's still professional. You can, of course, always become friends with clients. That's not what I'm saying. But you do want to remember that there's a closeness that occurs in there that you want to make sure that your boundaries are clear. Also, do your best. I know you're going to laugh. Keep work and home life separate. Seek support. So one of the things I'm doing here in Austin is I set up a thing called Fourth Fridays, where my office is open every fourth Friday from 12 to 2. Anybody can just come by. Sometimes we have guided discussion, but sometimes it's just to go and say, hey, I'm feeling stressed out and this is why. And seeking support from other colleagues who are going through this can really help you to realize that this is something it's systematic. It's something that's beyond your day, your work. It's something that's bigger than all of us. And if you meet together and talk about it. Now, one thing about talking about it with colleagues, it's great to talk about it with colleagues. Do not unload the stories of trauma without their permission. Ask them ahead of time, can I tell you this story of what just happened? Because you can traumatize your colleague by telling them some of these horrific stories. And as promised, there's a couple of resources. The first one is an AILA InfoNet document. I'm not sure how to get it outside of AILA, but I can try and find out. That's talking about the role of the attorney and how you can deal with trauma yourself. Trauma and Recovery, the book, is an excellent book about the trauma, post-traumatic stress disorder, and all of the psychological sequelae of trauma. It's not for lawyers. It's more about psychology and social work. So if you do this kind of work, it's a wonderful book for that. And that completes my part of this. I guess I will. I'll go back to the boardroom, I guess.
Yes, thank you so much, Karen and Laura. Thank you both for your tips on how we can better address our clients. And we do have a couple of questions, but as I'm going through these questions, if you have additional questions, please message me privately and I'll make sure that we address them as well. So our first question we actually have for Laura, and Karen, you're welcome to add in as well. But what are some tips that you have for getting a U visa certification when the police or agency that you're asking does not want to sign?
That is a really good question because unfortunately it's something that happens often. And so first things first, check to see if the law enforcement agency is educated about the U visa process and about the certification process. If they've never done one before, chances are they think that somehow they're filing on the victim's behalf. So sometimes it's just a matter of education. And I think the screen just popped up with Assistor Resources, which is really great because in our clearinghouse on our website, if you go to U visas and then go into law enforcement certifications, there's a plethora of helpful information there. But one of those is a article written by Gail Pendleton, who's our executive director, and it kind of goes into what you want to do in order to educate law enforcement. And sometimes that means bringing someone else in. Law enforcement doesn't always want to hear from lawyers that they don't know what something is, right? So if they have, for example, a victims assistance unit in the prosecutor's office, and you can get one of the social workers there or one of the administrators there to help you in getting the correct information to the law enforcement agency, sometimes that really helps them just hearing it from someone else. And then the second part to that is USCIS and Department of Homeland Security, both the agency and the department as a whole, has some great information that's specifically for law enforcement, and it basically tells them you are not giving them status, you're just certifying that they helped you, because this is the whole purpose of the U visa is to help law enforcement.
Perfect. Thank you so much, Laura. And there's another question for you, Karen. When you have clients who have had, in an asylum case, they have a credible fear interview that then later directly contradicts the story that they're telling you, whether it's in the timing of what they're talking about or other inconsistencies, how do you deal with that, with this type of issue in your practice when you then need to present the story before the judge?
Well, it depends on what resources you have available to you. So it happens a lot. A lot of times people haven't had the opportunity to work through their story, and when they go through the details, that's when they realize, oh, wait a minute, this happened first and that was second. And that's the nature of traumatic memory. So if you can get them to testify about what the details are and then ask them questions, if it's an affidavit form or if it's your direct examination in court. Well, wait a minute, you said before it was this. Why did you change your story? Something along those lines, and give them the opportunity to explain that. And they usually have a really good explanation for it too. If you have more time and the person's not detained or you have the resources available, then getting a psychological evaluation is extremely helpful. The psychologist can go through, get a diagnosis, and make a professional assessment that this person is credible, and that also discuss traumatic memory and how in a moment where a government official is asking them questions and they're in a rush, they're not going to answer the questions correctly. So you can have that person's professional opinion in there.
Perfect. Thank you so much. We have another question for Laura. And again, if you guys have additional questions, feel free to message them to me, and we'll have probably about a time for about 2 more. Laura, you mentioned the NTA policy that is now in effect. Could you describe a little bit about what that means for victim applicants?
Sure. I can't go into the whole thing, but fortunately, there's 2 webinars that are going specifically into the effects of the NTA memo on victim applicants, and one of them is actually tomorrow. It's a co-webinar by ASISTA and ILRC. And then next month, Gail Pendleton and I will be doing a webinar on this policy, on the NTA policy, and on fee waiver policy. So I'm just putting that out there because I know I won't be able to answer the question completely. But generally what it means is that in the practice that USCIS had before in relation to victims was that so long as the application or petition that was submitted was not fraudulent, then USCIS would not put that person in removal proceedings if the petition or application was denied. In other words, benefits applications were not used for enforcement purposes. It was a good policy because, of course, it allowed victims to feel confident, comfortable, unafraid of submitting a petition or application for relief. what the application of the NTA memo is essentially the NTA memo is going to be applied to victims in the same way that it is applied to anybody else. And DHS made that, or USCIS made that pretty clear in their stakeholder meeting on it. So specifically what that means is if a petition or application is now denied and that person is removable pretty much for any reason, although they say that they're still going through some prioritization, then that person will be issued an NTA after all administrative appeals or processes are final. So in other words, let's just take the U visa, for example. If the petition is denied, the NTA won't be issued immediately. They'll wait the 33 days that you have to submit your I-290B appeal. If you don't submit the I-290B appeal, then an NTA may be issued. But if you do submit your appeal, then an NTA will not be issued because that's not a final the administrative process that's available is not finalized, okay? And the other thing that I will say about that is that there's a brief window of opportunity, and that is that USCIS may, in its own discretion, even if the person is inadmissible and even if the petition or application has been denied, they may decide not to issue an NTA. That is an internal discretionary decision that can't. Ooh, it's 1 o'clock. Sorry about that. That's an internal discretionary decision that can't be requested by the applicant. So when you submit all your evidence, just make sure that you, as just part of your application, you have submitted lots of evidence for positive use of discretion.
Perfect. Thank you guys so much. This has been an incredible webinar. I did put a link in the comments or in the chat section for everyone if you would be willing to give us some feedback for future webinars or based on past webinars that you've really enjoyed. Please click that link and fill out the information so that our committee can be working to give you guys topics that you really want to hear about. So thank you so much, Laura and Karen. We really appreciate your time and your expertise in sharing on this topic. And please stay tuned for our next webinars. If you haven't joined the YLD ILS committee, or if you haven't joined the YLD ILS group, please do so. That was the link included in the invitation for this webinar, and you'll be notified about all future webinars. Thank you guys so much, and I hope that you have a great rest of your week. Bye.